Hi, everyone, and welcome back to Rush. Well, our next guest got a nice surprise when he found out he was on the same episode as Elizabeth Hurley. Who wouldn't want to be on this show today? Akash the Bloke, of course, you know him as our gadget guru, but today we're going to be talking about something completely different because he's also a notary public. First of all, Akash, what was it like to meet Liz Hurley?
Well, it's been a long time coming. I've been a big fan for many, many years. I think my wife is the one who might have a little bit of trouble with it today, but everything else is good. So.
She was so lovely, and I was saying she actually, if it's at all possible, is more beautiful in person.
She is, absolutely.
Are you going to be okay?
I'm fine, I'm good.
Maybe we'll leave Akash alone for a moment. No, we actually brought you here today to talk about something completely different. We're usually talking gadgets because you love tech stuff, but you're also a notary public. What is that?
A BC notary is we are basically a solicitor, so we do conveyancing, real estate conveyancing if you're buying or selling your home. We do wills, we do powers of attorney, declarations, leases, certified true copies, a lot of the documentation that's necessary for somebody who's living in BC. And
people usually encounter it for the first time when they are buying a home because you have to get documents notarized. Yes. But why do people go to a notary public instead of a lawyer? Well,
I mean, there's some things that when we don't do litigation or family matters, but what we do is conveyancing. We're specialized in conveyancing, and a lot of notaries, that's all they do. So they're very hands-on, concentrating on one particular field of law, and we do it quite well.
And what is a power of attorney exactly for people who haven't experienced that in life?
No, a power of attorney is a very important document. It allows somebody to do something on your behalf when you're not able to do it. So if you're traveling or if you're ill, we do powers of attorney, and enduring power of attorney. That would be for somebody who's preparing something now for a future event. So if an event that you would prepare a power of attorney now and later on you feel that maybe mentally you're not capable of doing, taking care of your own affairs, you have a power of attorney to have somebody look after your affairs for you.
And the big one that we brought you here today for is wills.
Yes.
Last will and testament.
Yes.
Let's talk about the statistics.
Well, you know, I think that word, last will and testament, it just it scares a lot of people. And it's one of those documents that is absolutely necessary, because if you figure out how not to die, let me know, because I haven't figured it out. You do need to have one. And the most important thing is that we work hard during our lives. We strive to build our future, and this is one way to protect the future.
And we always think of the elderly as needing a will, or maybe as soon as you do, knock on wood, get ill, that you should have one. But I guess every adult really should.
Yeah, basically if you're over 19 years old, or actually if you're in the military and you're under 19, you can actually prepare a will. And it's an important thing to prepare and start working on the documentation, prepare it, and as life changes, as time goes on and your family situation changes, you can update your will anytime.
Is it complicated? Because I have to confess, I am in the same boat as a lot of people. I don't have a will. I know that I should.
You should, yes.
It's one of those things that seems complicated to me. So where would I begin?
You know, that's a great question. And I have that with a lot of people, is like, we don't even know where to start. And what I tell people is, in a will, the things that you need to think about is what you have, who you want to give it to, and who's going to look after it. Who are the people that are going to look after? So basically, one really good way to do it is make a list of family members. I encourage people to make a family tree. And from that point, make a list of all your assets that you have, who you would like to give it to, and of course, who's going to look after it. And that's the executor and the trustee. And a really important part is, I get this a lot, is people that have, we have young kids, we don't have that many assets. And I go, well, one, your kids are your biggest asset. And if something was to happen to you, who's going to look after the kids?
Right, of course.
And they're like, oh, we haven't figured it out. We don't know if it's going to be my wife's sister or my mom, or, you know, we haven't figured it out yet. And the first thing I tell them is that if something happens to both of you and you haven't figured it out, now how is somebody sitting in Victoria going to figure it out for you? They've never met your kids. They don't know your family. How is that going to happen?
And God forbid something like that does happen to someone, but you want to be prepared. Okay, so I've made my list. I've got my little family tree.
Yes.
What happens now?
Okay, so what we do is we sit down with you and we ask you a lot of questions. We ask questions for you, we have you ask us questions, we take all the information down and we start preparing a draft copy of the will. And in our office, the procedure is we have you come back in about a week or so when everything's done. You come back, you read the draft copy, we go through it, and if everything's fine, then we print the final for you and prepare it. And wills can be general, so you can cover everything. You can say, if something happens to me, it goes to these particular people in equal share. If something happens to them, it goes to these people. Or you can say, I want this item to this person, this painting to this person. I actually had one client that she had 5 beautiful kimonos. She had 4 daughters and a niece. And she wanted very specifically a particular kimono to go to a particular daughter and niece. And I said, well, the problem is that kimonos don't have serial numbers on them or anything, so we can't do that. So what we did is we described the kimonos as best as we could. And then once she had the will prepared, we took a photograph of each kimono, and we dated and wrote on the back that this kimono goes to such and such daughter or niece, and put it in the envelope with the will.
I guess you can go simple or complicated depending on whether you're the kind of person that wants to have those kinds of things. And
Exactly.
I mean, when we're talking about not having a will, oftentimes with some families, that's when people can start fighting over things.
Yes.
And as if dealing with a death isn't as difficult as it can be.
Yes.
I mean, that's the worst case scenario,
Well,
especially if you have property and belongings and things that are important.
This is the most emotional time that you'll be going through, and to deal with financial items on top of that is just compounds it too much. So we tell people, make sure you have everything in order in place, and it helps to discuss with the children. I had one client where they have 3 children, and they invited them over to what we call a post-it party. So the children came over, they gave them different color Post-it notes, and they said, walk around the house, put a Post-it note on what you like, and discuss it with your siblings now while we're still around. So, the kids are like, okay, I want this sofa, or I want this art piece, and they kind of figured it out in advance, and it just made everybody feel better.
Well, it's funny because when my dad passed away, my sister and I were bequeathed everything.
Yeah.
Together.
Yeah.
But we get along really well, so we did the same thing. We flipped a coin and did, you pick one, I pick one. And there were no disagreements.
No, I had one client where they wanted, the 2 brothers had saved up their money when they were younger and bought a guitar that belonged to Led Zeppelin. And so when the husband and wife are in my office, and the husband says, well, I only have one special thing. If something happens to me first, I want this guitar to go to my brother, and then everything else to my family. And his wife is shaking her head, and she goes, you know what? Please give the guitar to his brother. He thinks he can play it, but he can't. So I'm glad that's going over there.
And how much time should one allow when they do have to make the appointments and meetings with you? Just because along with thinking it's complicated, I also am associating really time consuming, and that's why I always put it off.
Yeah, and that's really up to you. We can take instruction from half an hour to an hour, and then the second appointment is the signing. But complicated wills, we've actually had clients come in 2 or 3 times to go over assets. And that's really relevant today with blended and mixed families. And you get into a situation where there's a divorce, or either you have a stepchild, and those things are really important. And what I get a lot is somebody says that if I'm a single mother, something happens to me, it goes to my child. I said, that's great, okay, but what if something happens to both of you and you don't have a will? And she goes, well, what do you mean? I said, well, if something was to happen to you, it would go to your child, but if something was to happen to both of you and now you don't have a will, that child's next of kin is the father, maybe your ex, and now that child's assets are going to go to the father. And she goes, well, that's not what I want. That's not my intentions.
It's funny because I think it's just human nature that we don't want to think about these scenarios, but we have to think of these scenarios, otherwise.
Yes.
There we go.
It's happened to me before. A client comes in and she says that her husband wanted to make the will. She didn't want to make a will because she felt that she makes the will, she's going to pass away right away. So I said to her, okay, here's what I'm going to do. I'm going to prepare the will. If you want to sign it, great. If not, don't worry about it. It's been 12 years and she's still around with us. So.
Now, and in my mind, a will is also this giant scroll.
Well, yeah.
I have this vision in my head. What does it look like?
I've got a red seal and some candle wax here if you like.
That's what I picture.
Yeah, and that's what it is. It's that old that will and testament, and I think that's where it comes to. Wills, when I became a notary 15 years ago, wills were quite complicated in the wording. The wording has become now standardized English, a lot less Latin, a lot more clear English. And I think that's because the courts have seen that let's make it clear for everybody so the testator, the person making the will, can read it easily, the recipients the beneficiaries can read it. It just makes it easier for everybody. And
okay.
Yeah, you don't need to get that complicated anymore.
We have a couple of questions from our audience. Sonia is on the social media desk. Sonia, what is our first question for Akash, please?
Hi, well, our first question is about what is a way to make or compose a will in a way that will minimize sort of your descendants arguing about assets afterwards?
Well, the easiest way is to give an equal share. So if you have 3 children, 1/3 each, you have 2 children, 1/2 each. That is basically under the Wills Administration Act, the natural natural inheritance would be to your spouse and to your children. equal share. Now, if you're not giving an equal share, that's where there's a chance of somebody applying to sue the estate or make a claim against the estate.
Okay, we have time for one more question, Sonia.
And what are some of the biggest challenges that family members face when a family member passes on and does not have a will?
That's a really good question. And not having a will is it potentially takes a lot of time. Having will, you can finalize your estate between 2 to 6 months. And depending if it's a simple will, if you don't have a will, it can take anywhere from a year to 2 years. And the biggest challenge is who's going to look after it, who's going to receive what. There might be some liabilities that the deceased has. There might be some assets. Maybe they've loaned some money out. We had, I remember when I was studying to be a notary, there was a case with a woman. She had no other relatives, no cousins or anything like that, one son. And she wanted to give everything to charity. And that is a contradiction to the Wills Variation Act. But the reason why she wanted to do that was because her son was in jail. And the reason he was in jail is attempted murder of her. Yes, so she had so she had quite a valid reason why not to give it to him. But the matter is that because she made a will, now that son had to apply under the Wills Variation Act to receive a benefit of that will. Had she not made a will, by law, under the Estate Administration Act, he would have received automatically.
My family seems completely normal in this moment. Akash, thank you so much.
You.
For more information, you can go to subloke.com to find out everything about what Akash does. We're going to take a quick break. And when we return, we're going to get rocked with a random act of kindness right after the break.